The thing is, you needed to get the right balance between feasibility for industry, embedding practices that industry was already having in their own organization, but also making sure that they adhered to the scope and the thinking of the AI Act.
Hey everyone, I'm Ron DeJesus, Field Chief Privacy Officer at Transcend, and welcome to The Breakdown. This is a new series that we're doing where we essentially talk to experts in the privacy, security, and AI space and break down and unpack complex topics. And I'm so happy to have Dr. Laura Caroli as my first guest. Dr. Laura Caroli is a senior fellow at the Wadhwani AI Center at the Center for Strategic and International Studies. And she's going to help me break down the General Purpose AI Code of Practice, which was published in July. Welcome, Laura. Thank you so much for coming. And I actually just remember we first met in Brussels last year, right after the AI Act had essentially come into force. And we were sitting at a cafe and we were having a conversation around like, what does this mean? And I've always wanted to have you on some of my content. So I'm really excited to have you here today.
Hi, Ron. I'm really happy to be able to talk to you today. Yeah, it's been a while, long time coming. I still remember that conversation.
Yeah, long time coming in. Before we get started, Laura, give me a little bit of a background and insight into what you're doing at the actual CSIS. I'd love to start there.
Yes, I'm trying to do research both on the implementation of the EU AI Act to try and explain what the important insights are and what people need to know about what's going on. And in particular, I'm focusing also on US legislation on AI, what is happening in the US. I'm learning a lot about state bills on AI. There are many that catch my eye in terms of similarities, differences with what we did in Europe. I do research on what is happening at the international level in AI governance, especially with the shift in the US administration and what it entails at the international level, the big trends, the shift from AI safety to security, the growing importance of standards, international standards on AI and influencing the standards. So these are a bit the topics that I work on. And I also try during my time at CSIS as much as possible to keep transatlantic dialogue as alive as possible and to show that there are many more commonalities than differences between the two shores of the Atlantic.
And you're absolutely the person to be doing this, Laura. I feel you've been at the forefront of these issues ever since your work at the EU Parliament as working under MEP Benefit. So definitely love to see that you're now stateside working on these issues. So obviously, as an operational chief privacy officer, I always love to talk about, actually, this is the genesis of the breakdown, which is to break down these complex topics. And we're going to be talking today about the code. Could you give me just maybe a 30 to 60 second TLDR, Laura, of what the code is, like what it's comprised of, and just so that professionals have a basis through what we're talking about today?
So first of all, the Code of Practice is a voluntary compliance tool. It's meant to operationalize the requirements of the EU AI Act just for general purpose AI models. So not narrow high-risk AI systems, but general purpose AI models, both small and powerful. The requirements in the AI Act, you will see Articles 53 and 55 are pretty high level because when the AI Act was negotiated, there was the field was still nascent, and so as we basically decided not to intervene too much in the weeds, in the details of how to comply with the basic requirements that I will list now. One is for all models we have technical documentation and a copyright policy. And then for the most powerful models, we have risk assessment, mitigation, model evaluation, and cybersecurity measures. These are just for the most powerful models. So these are very high level. The code of practice details how to do these 6 things in a streamlined way as much as possible. And as you know, Ron, because we will see, you also participated in the drafting process. It was a multi-stakeholder type of process that involved 1,000 different
Yeah.
experts for months, for almost a year, and this is now the result.
I'm glad you brought that up, Laura. So as you mentioned, I was fortunate enough, well, maybe fortunate's not the right word, but I was able to participate in the code of practice plenary sessions. And this was my first time participating in a plenary session of this sort. I did get the sense that a lot of it was a little bit performative. I did provide feedback on, for example, some of the transparency requirements, but it wasn't an actual venue where there was a lot of real time engagement, debate, that sort of thing. There was definitely opportunities where civil society groups or other groups could provide maybe very short presentations. Lots of the times people were cut off kind of pretty abruptly. And then we would come back and get another draft that would implement the guidance. And then, several of these sessions happened over the course of several months that you had mentioned. I thought the feedback that I kind of generally saw from others who were participating was they also found it was hard to provide feedback. There was an imbalance of voices. Some felt that the real discussions were taking off place of the plenary sessions. Now, you specifically opted out of these working group sessions, but I know that you decided to, participate in other ways. Could you tell me how you maybe met with other folks outside of these specific formal sessions?
Yes, so indeed, Ron, we talked a bit in the past month, so you do know that I decided not to participate because I thought it was not my place since I took part in the negotiations for the UAI Act per se. I thought it was not my place. It was rather the place of external stakeholders to participate in how to operationalize the rules. But nevertheless, I knew how important the process was. I participated in the, let's say, the talks that led to the establishment of this platform. Because at the beginning, I don't know how much you know about this, Ron, but at the beginning, the code was not supposed to necessarily involve that broad a range of stakeholders. It was a process that led to many letters from civil society, from the parliament. I was personally involved in drafting letters from the parliament side to ask the commission to involve as many stakeholders as possible, industry, but also civil society, independent experts, lawyers, rights holders, because we knew how important it was to have a diversity of points of view, and also to make sure that the chairs and vice chairs of the working groups in which the work was divided were independent experts, so not coming from a company or an institution or the commission itself. And we managed to obtain that. And so, as you know, there were 4 working groups, each with their their chair and vice chairs, etc. I know that indeed, when you have 1,000 stakeholders and you have a few plenaries throughout the process, it's not easy to make sure that everybody can make their voice heard. Of course, there is the phase for written comments, and I'm sure you participated in that as well. So it was also another way to participate. But indeed, discussion, this is the feedback that I got also by observing. I've been writing about the code of practice and the implications of the different drafts across the dialogue was really important, and it was lacking. I got this feedback from several stakeholders. And that is why at some point I got this idea of creating a small group to reflect together, because I thought what was missing was especially dialogue between civil society and industry. I felt really since the very beginning that this was lacking. This process was meant to be in a way owned by companies, by industry, but also listening to civil society. And I had the impression at some point, especially at the beginning, that civil society was trying, to take over, but without talking to industry.
100%.
So I really try to have them speak to each other in a balanced small group. I'm not going to say who was involved. And the feedback I got from this discussion was that they managed to finally understand each other's points of view. So that is why I thought it was particularly valuable. And I wish we could have done it in a more structured way, but in a way we cannot, this was a kind of an experiment, okay? This participatory type of platform to draft a document together with 4 iterations of drafts and comments, etc.
Yeah.
So I think all in all, it was a very interesting type of process. It can be improved in the future, but you cannot say that you have so many processes that are as inclusive as this one was.
Absolutely. I don't envy the work of the chairs. They definitely had their work cut out for them, the number of comments that they received. And I think overall, it at least gave a window into the processes of the folks behind the code. So now we have the code, whether we like it or not. And I know you've been pretty vocal, not only with respect to the code specifically, Laura, but you've been pretty vocal about some perspectives out there around the EU AI Act being too onerous or some of these perspectives that are more, I would say, pro-industry, if you will. I was wondering, now we have the code. What are your initial reactions to the contents of the code? Are there any glaring gaps from your particular perspective? Maybe we start there before we get into what you think is actually beneficial in that series of documents.
So, Ron, this code was very important to get right, of course. It was the first type of document of this kind to deal with frontier AI, powerful AI models, sort of a pre-standardization effort in a way. So there was nothing out there to compare it to. And the thing is, you needed to get the right balance between feasibility for industry, and so embedding practices that industry was already having in their own organization, but also making sure that they adhered to the scope and the thinking of the UAI Act. So, for example, the risks you have to control for needed to include societal risks to fundamental rights. One of the moments in which I was the most vocal about how the process was not necessarily going the right way, in my opinion, was when the chairs and vice chairs of the safety and security chapter decided to link the risks to control for only to the high impact capabilities of the model. And so they estimated by this direct link that risks to fundamental rights were not necessarily a product of the high impact capabilities of the model, but rather for other reasons. And so they did not include risks to fundamental rights in the main risks that model providers would need to control for.
I see.
And this was wrong. It was not in accordance with the letter of the UAI Act and the spirit. And so me and several actors of civil society, but also the parliament itself, we tried to really correct course in a way. At the same time, other problems that were there, one that was blatantly evident until the very end, and we even know the reactions now, was the conflict between rights holders and model providers on copyright policy and copyright transparency. In a way, AI Act and the European regime on copyright is the one that protects rights holders the most across all the platforms that you have regulations on AI across the world, because we have this opt-out policy stemming from the copyright directive. So not from the UAI Act. The UAI Act just implements the copyright regime that you have in the EU. That was also the object of a very conflictual debate. I was there. I remember I was much younger, but it was horrible, like super, super conflictual. So I think that the template that the Commission released and the copyright policy measures that you have in the Code of Practice will also be the object of still a lot of polemics, because rights holders estimate that they are not sufficient to protect their rights, whereas industry, of course, was of the opposite opinion, and that it was too intrusive. I mean, you have in the US, for example, the opposite approach right now, as companies have basically the right to train the models on whatever data they
Anything.
have. Trump, in announcing the AI action plan just 1 month ago, said something like, you cannot expect us to pay for books." I remember that I reacted to this by
Such
saying,
an
okay,
American
then
perspective there.
I go to Barnes and Noble, to Kramer's, and I just steal the books because apparently I don't have to pay anymore. So great. And so, yeah.
So lots of stuff you've identified as gaps. Are there anything for example, maybe the transparency templates in the transparency section, are those sufficient from your perspective? Is there anything in the code where you're like, wow, that's actually really how this should be interpreted and applied from a code perspective?
Listen, there is also another gap that I wanted to mention, which is the fact that the transparency side, so the technical documentation side, is not only meant for public authorities, so for the AI office, which will enforce these rules for models, but also there is a specific section for downstream providers. So basically, if you want to build an application based on a model, you need to have a certain type of information from the upstream, from the model provider, because you need to know, how that model was built, what it controlled for the data, the parameters, etc., etc. And if you don't have enough information, you are not able to control your own application that you're going to build and that you're going to sell and commercialize. So it's important that this process is complete. And I saw some research already from downstream providers denouncing that the details in the final draft are not sufficient to really enable a comprehensive control for downstream providers. But this is something I don't hear much about. It's less sexy than the copyright debate in a way. And the fundamental rights one, we fixed it in a way. So in the end, I'm very happy that the drafters took into account what we were saying a few months back when the third draft was published, and they now include societal risk and fundamental rights into the risks that model providers have to control for.
100%. And you actually just mentioned the White House's AI action plan. And I know you're doing a lot of work on identifying or talking about this convergence, right? Where we have, and you mentioned early in the beginning, where we have seemingly a set of different perspectives and cultural attitudes around AI governance versus the US. But I think the work that you're doing is actually showing that there's lots of similarities there too. Can you talk a little bit more, Laura, about what you're seeing, not only kind of across the Atlantic? Well, you're based in DC, but I guess I'm actually based in Portugal right now, so I can say that. So stateside, like what California is doing, what other states might be thinking about, and how there might be alignment or, at least similarities in terms of AI governance requirements there.
Yeah, thank you, Ron. I'm
Yeah.
actually very happy to talk about this because this is the object of my next publication, my upcoming publication that I hope will come very, very soon. It's about this convergence that I see indeed but to be precise, about frontier AI governance. So,
Okay.
governance of powerful models. A few US states are working on this topic, California, but also New York approved its own bill already in June. So it just needs the signature, probably with some amendments that will be negotiated in the next few months. But still, New York has approved its own framework. We have Illinois, Michigan, even Massachusetts. in any case, I compared all these frameworks because, when you read them, these are very straightforward bills. When you read them, find this I already heard of. This reminds me of something. Basically, I have a table that will show that the world, at least the Western world, in a way, because we always forget about the global South, etc., in AI, and this is a disaster. But still, US, EU, national and international frameworks such as the Seoul Frontier AI Safety Commitments that leading AI companies took last year at the Seoul AI Summit, which was held, I think, in May 2024. They took these commitments. If you read them and you compare them with the US state bills I mentioned and the code of practice, you will see a lot of common elements. For example, what is the document underpinning the governance measures of all these frameworks for model providers? The Safety and Security Framework or Safety and Security Protocol, a strategy document that outlines the overall processes and practices that the model provider will implement internally in its organization to make sure that the models are safe and perform the way they are intended to perform. So this is the key measure, the Safety and Security Framework or Protocol. All the US bills have this. The Code of Practice has the Safety and Security Framework, the Seoul Safety Commitments as well, and also an industry-driven framework that I include in my analysis, which is the one proposed by Anthropic just a couple of months ago to advance AI governance for companies. They also have this framework as the pivot measure.
What do the
Then,
U.S. laws, Laura, form as the basis as their security kind of framework? Are they NIST standards, or like what are they referring to?
so in this case, we don't have a standard of how to do frontier AI safety. Because the standards for, I think you refer now to the NIST RMF, the Risk Management Framework, or the ISO 4201 AI Management Framework. These are standards that were already published 1 year ago and 2 years ago, and that are very, very important in AI governance in general, but they are more suited for AI systems, so more controllable applications of AI,
Okay.
and for companies
More
that
for deployers,
implement.
right?
Also for deploy. So in a way, now you lead me to another topic that I didn't want to mention now, because otherwise we can stay like 2 hours and you have to excuse me, but I
Well,
have
this
a
is the
lot to
point
say
of
in this.
this is actually really great because this is the point of the breakdown. I'm kind of digging
Yeah.
deeper and trying to break down the concepts that I find as an operational professional complex. So feel free to go down that rabbit hole for sure. Yeah.
Okay. I did another type of research, state bills of another kind. So now we just analyzed the frontier AI safety bills. There is also another group that is about algorithmic discrimination. So high impact risk based AI frameworks, more like the high risk framework of the EU AI Act, if you will, but with many differences. I already published something in this regard when the Virginia bill was vetoed by Governor Youngkin in March. That bill was a bill resembling, by the way, the Colorado AI Act that was approved last year, that identified a few high impact areas, so a few high risk areas, if you will, like the AI Act, where the use of AI by public authorities or also private could lead to discriminations, impact on consumer citizens' rights. So what are these areas? Each bill is different in this regard. There are several, like it's Virginia. Okay, now Virginia is dead, but you have Colorado, you have New Mexico, and others that I mentioned in my article. These bills are about, education, employment, sometimes law enforcement, sometimes going to prison or not, having access to housing, having access to a loan. for example. In a way, some similarities with the high-risk use cases of the UAI Act, but
Right.
the UAI Act has far more. If you compare the sheer number, like the comparison is striking. And what I find interesting in these bills that is pertinent to our discussion, Ron, is that many of these bills mention the standards that you just mentioned, the NIST RMF or ISO 4201, as an appropriate way to comply with the requirements of these bills, which are, let me be frank, very, very light touch compared to the UAI Act.
Mm.
They are usually, the developer has to disclose to the deployer what measures he put in place when he built the AI system. It doesn't even say that the developer has to do a certain thing. It just has to disclose what it did. And the deployer then has to implement a risk management framework. So the deployer, in a way, seems to have much more substantial commitments to take, tasks, because implementing a risk management framework is a much more burdensome task than just disclosing what you did when you built your AI system. So basically, it gives you much more responsibility. Then it has also, the deployer has disclosure obligations towards the consumer, towards the authority, etc., etc. And so, in doing so, even the deployer can use the NIST RMF or ISO 4201. The Virginia bill that was vetoed again, but I found it interesting because it was the lightest one, but also it had this element that I'm gonna mention. It had the presumption of conformity. It said that whenever a developer or a deployer of an AI system would use either the NIST RMF or the 4201, they would be presumed to be in conformity with this build. In a way, this was a concept that was mutuated from the UAI Act, which is product safety legislation in the EU. It is a concept that you have in all product safety types of legislation in the EU, on toys, on machinery, on medical devices, on lifts, etc. When you use a standard, a harmonized standard that is officially recognized as valid for that purpose, you are presumed to be in conformity with the law. So you can assess yourself and declare your system and declare, I have complied with this standard. So I have applied all the measures that the standard includes, all the processes, the checklist. I have done this. I follow the standard to the letter. So I'm presumed to be compliant. You write this in your declaration of conformity. And when the market surveillance authority will track your products, you can just show this document and you're good to go. So it's a
So
very
if I that was a
flexible.
lot.
Yeah.
That's a lot
Sorry.
to. No,
You
no, no.
said
This is
rabbit hole. I went down the rabbit hole.
my gears are turning as you're talking, Laura. So I just wanted to kind of bring it back to the general purpose AI code of practice, which I know where I'm conflating a bit in my head, because what I'm seeing is obviously the code is specific to providers of models, but now we're
Yeah.
veering into the territory of states that have requirements for deployers to demonstrate their compliance via NIST,
Mm-hmm.
etc. So taking that into account, what's the EU equivalent then for deployers? In terms of, like, we've talked about the code, which is specific to developers, but where's my touch point for chief privacy officers like me that might be deploying AI? Is there an EU equivalent kind of, not code, but like set of requirements?
So
I'm trying to like connect
yeah,
all the dots here,
yeah.
So yeah,
That's
yeah.
why I really maintain that the algorithmic discrimination bills that you have in the US are not like the UAI Act, because they impose much more requirements on deployers than the UAI Act does, because the UAI Act
Mm.
only has one article for deployers. Well, actually one and a half, let's say. The other one is the fundamental rights impact assessment. But I have been talking to some state legislators, and I've been asking them this. They are concerned that the bills are too burdensome on small companies, on small businesses and small deployers. Okay, then I asked them, why would you ask them to implement a standard? Do you know what a standard is? Like sometimes uh, people think it's simple, you just buy the standard online and you apply them. It I actually bought the ISO 4201. It cost $200 on the website. You can
Did you
also
expense it?
forum shop. Yes. Well, it was hard, but yeah. No. And I try to ask, for example, a school, since a school might be a deployer at some point of AI systems used in education. They are high impact to evaluate access to a higher level of education for a student. So they can have an impact if they don't function properly. Ask a school to implement 4201, and I want to see their faces. They are not technical experts. They are not engineers. How can they comply with a standard of that sort, which is a very technical document?
100%.
And that is why the EU AI Act doesn't have this reasoning at all. Deployers don't have to apply standards. They just have to monitor the performance of the system, follow instructions of the provider in the AI Act case, cooperate with authorities, flag if there are problems with the system, if it's malfunctioning, inform consumers, which is a bit easier to do than apply a standard. And in the case of public authorities and banks and insurance, perform a fundamental rights impact assessment, which is not an AI management system. It's just basically a list of questions that the deployer needs to think about and answer. Like, is my system in this particular context impacting rights of people because, for example, my bank is in a field office in a neighborhood where I have a certain percentage of population that is belonging to a certain minority. The AI system might not perform necessarily well on that minority. It will say that they don't have right to a loan, for example.
Mm-hmm.
So what does it mean? It means that when I use this AI system, I need to think, will it impact their rights? If it will impact their rights because it's not performing well, I will have either to abstain from using it because maybe it's not the right tool. I have to think of something else. But without touching the AI system itself, because otherwise you become a provider. So nobody asks
Right.
a deployer to really get into the weeds of how the system is developed, but rather to implement, like, I don't know, a specific complaint mechanism, to hire a fundamental rights expert of that particular issue, or to have a specific communication campaign on that, like flagging to people, be aware that in these cases the system might malfunction.
So can I pause you there, Laura? And I promise I'm going to wrap this all up in terms of like how this applies to the code for the listeners out there. It's all working in my head now. So, but before I get there, so you've mentioned that from a deployer perspective, which again, I think in your talk with Lucilla Scioli, who is the director of the EU AI office, she had actually called out specifically that people forget to remember that 95% of the F500 is not going to be subject to these requirements simply because they're not developers of AI,
Yeah.
which is something that I think is incredibly critical to remember because again,
Yeah.
we keep forgetting, and I think there's a lot of perspective out there that the EU AI Act is too onerous, right? And I think that's definitely a myth. So my question is, you mentioned from a deployer responsibility perspective that they might have fundamental rights impact assessment requirements, transparency requirements, complaint mechanism requirements. That being said, if I again come back to my role as a chief privacy officer,
Mhm.
presumably the GDPR and even stateside, state regs around privacy, those are the fail safes when it comes to identifying privacy risk. It's not the EU AI Act. It is
I know.
existing, right?
Yeah.
existing
You're
privacy
completely right.
legislation.
GDPR already has the data protection impact assessment, and it also
Okay.
includes a right to information, right? When the AI Act has a right to an explanation, it's more or less inspired by GDPR. So the fact of explaining to the consumer you didn't get the loan because, like, you cannot answer. The computer said no. I've been told this a few times, so I was particularly sensitive to this not happening in the future. So from now on, with the UAI Act, a bank will have to tell the consumer, you didn't get the loan because of this particular factor in that was considered a negative factor by the algorithm. And this is already similar to what you have in the GDPR. So yeah.
Right. Amazing. So this is actually a great kind of segue into, again, a lot of, we're both very active on LinkedIn. And when the code came out, there was a lot of,
Oh, you're great on
I wouldn't
LinkedIn.
say,
You're a
not
star.
there was a lot of stuff out there saying, be aware of the code, make sure, you get a handle on what the code means. And I was just sitting there thinking, I don't work for Anthropic. I don't work for OpenAI. I don't work for XAI. What are you actually telling CPOs to do? So I wanted
Mhm.
to get a sense from you, Laura, just break this down for me in terms of, I'm a chief privacy officer. I know the code is out there that applies to developers, but what can I take from the code in my day to day as a chief privacy officer? Just again, I know it's not applicable to me. It's a voluntary code, not applies, and if a developer wants to um, comply with the code, it's voluntary. I get all that, but what are some elements of the code that would help me in my day to day as someone that is also responsible for AI governance at my company?
Well, I think that the structure of the code has some interesting elements. So thank you for clarifying that you
Yeah.
don't have to comply with the code. First of all, again, it's voluntary and only model providers are encouraged to sign onto it, especially the biggest ones. But in it, apart from the transparency measures, so some details on the documentation on the data sets, the training data sets that you have to feed, to train the model, can be of help, but you have them already in the technical documentation side of the UAI Act per se for high-risk AI systems.
Mm-hmm.
So Annex 4 and Article 10, but for providers, not for deployers, because again, the technical things are for providers to provide. So I don't think Transcend is a is a provider per
We're
se.
not a
This is
provider
like
yet.
yet, maybe at some point. But another another thing that is, I think, useful is what you have in the safety and security framework, safety and security chapter. You have more or less a methodology for risk management that is explained in a very detailed way and detailed steps. I think that some useful takeaways that you don't need to comply with, but they might provide you with some insightful tips are, for example, how to measure what is an acceptable risk and what is an unacceptable type of risk. So, for example, dividing the individual risk into thresholds and
Mm,
knowing when you are about to go above the unacceptable threshold and what to do to bring it back. This is mainly for providers because they would need to apply risk mitigation measures, model providers in this case, but the mentality of thinking, the methodology of thinking, okay, I'm deploying this system, I'm a chief privacy officer, I see these risks, but they are in check. So I need to know more or less what I consider acceptable and what I consider
right.
unacceptable. And when, the line is going a bit too
Got it.
high into the unacceptable risk.
So
That is
super
a
helpful
useful.
guidance in terms of understanding or refining my own risk appetite at the company when it comes
Exactly,
to, got it.
exactly.
That's
And also
super
the
helpful.
fact of constantly updating your framework, your risk management framework, like, because the
100%.
system evolves and the data also evolve into it. So
Yeah. And I told you before, Laura, when went back when we talked last year, a lot of us now as CPOs are being given this AI governance hat, and we're expected to not only address privacy risks, but again, look at it from a multifaceted perspective. Even copyright and stuff that's not in our wheelhouse, we're now being asked to address through these governance programs. So this is really helpful for me as an operational professional. I do have two questions for you. I think we have time for two questions. One of them being, you mentioned earlier on, that the EU AI Act has a much more comprehensive, perhaps, and also just a lot more examples of what banned and high risk activities are versus kind of the
yeah.
US counterparts. Do you think that's just cultural? Like, why isn't the US concerned about specific things like, you know, real time monitoring of emotive states or something like that in workplace environments? Like, why is it that the EU is actually more comprehensive in its identification of what they consider high risk versus what these bills you're researching kind of focus on?
Yeah, I think it's a combination of mainly two factors. First of all, the sensitivity to privacy versus having a certain product available for consumers. So I do see that Americans are a bit less sensitive to the intrusion of companies into their own private life, a bit
Mm,
less than, for example, Germans. Even Italians are much less sensitive than Germans on this. Privacy in a few European countries is sacred. Like, there is nothing that trumps privacy.
mhm.
In
Yeah,
the US, it's not necessarily the case. For example, I do see that freedom of speech is much more important than privacy in the US.
interesting. Yeah,
What I've been learning so far, especially with the polemic around DSA, DMA, etc., digital censorship, etc. So this is one factor. The second factor is the juridical culture. The US is more common law, like Anglo-Saxon, like type of common law based type of legal culture that is less based on positive regulations, but rather dealt with in court. First of all, a lot of the critics of US state bills on AI, there is a whole movement of commentators, especially Republican leaning think tanks that maintain that there is no need to regulate AI in the US because it is already regulated. There are already consumer protections, there is already liability, blah, blah, blah. And you do have agencies that enforce consumers' rights. You have the FTC and others, like, I'm not super an expert on all the consumer authorities and privacy, etc. But systems are already in place, and when agencies do not step in, you can always go to court much more easily than in the EU. The EU, by contrast, is more precautionary based. So it prefers to avoid problems before they present themselves. So before you have to go to court,
got it.
by having all these regulations that tell companies how they have to behave to avoid problems from materializing.
I see.
So this
One
is
more,
to
yeah, last question for you, and it's might be a more of a surprise question, but as I was
okay.
researching, as I was researching some content for this session, I noticed that on the commission website, it gave a list of the folks that had signed up to the code. Your typical players, Mistral, OpenAI, etc., Microsoft. There was a footnote at the end saying that XAI only signed up for the security
Safety
control,
and security chapter.
safety and security chapters. So can you actually just sign up for specific chapters of the code? I didn't know that you could kind of do it piecemeal, but apparently XAI was able to just demonstrate maybe their adherence to a third of the code and not the others. So that I found that interesting. I was wondering if you had any insight
So
on that.
yeah,
But yeah.
yeah, that's interesting for me as well. It was a very original type of.
Yeah. Seems like a
So the
concession
thing is,
made to appease, maybe such a big player in this space,
yeah,
but I
but
don't know.
I don't understand. First of all, I don't think the AI office was expecting a company to only sign a specific part,
Mm,
especially since XAI is a large model provider. Grok is a model with high impact capabilities. It's among the biggest. All the latest versions of Grok are above the thresholds. So in the AIX, so they are considered a model with systemic risk. So they have to comply with the highest set of requirements. Again, they have to transparency, copyright, but also risk assessment, mitigation, model evaluation, and cybersecurity. They only sign to this part. But
right.
what is interesting to me is that the transparency part and the copyright part, more or less, the requirements are already spelled out in the UAI Act. They are not as high level as the highest ones, so
Right.
risk, the assessment. So even if they don't sign, so they didn't sign, evidently, you have an annex in the UAI Act just detailing the technical documentation. So the transparency part. And you also have two specific requirements for copyright policy. So first you have to have a copyright policy in place. Then you have to make sure that rights holders can opt out of from giving their content to feed your model,
Hmm.
to train your model. So basically, whether or not they sign, they will have to comply anyway.
Right.
Both transparency and copyright provisions, which if you look at those chapters of the code of practice, they are not the longest ones.
Not at all.
Is the safety and security
Right.
chapter.
So, which
So
was
it's
odd to
actually
me
very
that,
good that they signed that part.
yeah, it's good that they signed the most complex piece, but also
Yes,
odd to know, it's a pretty, the transparency and copyright ones, I think they're less than 10 pages each. So it's a
exactly.
peculiar stance. But anyway, Laura, thank you so much for being on the breakdown. This is so incredibly helpful to unpack how the code affects CPOs and other privacy leaders. But I'm so thrilled that you were able to make it. And we're looking forward to your paper that's coming out addressing the convergence of these different perspectives. And when is that coming out again, Laura? Maybe for our listeners?
They told me a couple of weeks.
Okay. We'll look out for it. And I'll also include a link to your other paper on, I think it's in the Tech Policy Press.
The op-ed,
Yep.
the delays on the code of practice, or
Yep. Yeah. Awesome.
also we didn't mention enough one element to look out
Feel free.
for,
Yeah.
which is standards for transparency, trustworthiness of AI systems, the standards that are being worked on as we speak for the EU AI Act compliance, and also that are informed by international standards like 4201, blah, blah, blah. This is a whole world in itself where more or less what you see on the code of practice process is more or less replicated, but in a much more structured way. And that is where the real action will be in the upcoming months. And that will be interesting also for, at some point, for deployers which will not have to comply with the standards, but still might be interested in shaping how standards are developed.
Are they
This is
guidelines
our
or standards? They're actual standards?
standards.
Okay. Well, maybe I'll have you back on the show for part two
Just
and
to
we'll
talk
break
about
that
standards.
down. Yeah. But Laura, thank
Okay.
you so much again. Appreciate it.
Thank you. Thank you. It was fun.